All right, good morning. Welcome to the morning briefing. Today is Monday, December 20th, and it's episode 156. I'm Phil Brandt. With me, as always, is Burt Garland, shareholder with Ogletree Deacons, and it is our goal to keep you informed so you can more effectively lead your organization. Today's topic, the OSHA's Emergency Temporary Standard. Last Saturday at approximately 9:30 a.m. Central Time, the U.S. Department of Labor issued a press release that the Sixth Court of Appeals had dissolved the Fifth Court stay order of the OSHA Emergency Temporary Standard on COVID vaccine and testing. All right, Burt, I don't know about our listeners, but I'm a little confused about which court is doing what. Can you kind of frame for us some of the things that's taken place, kind of where we're at?
Sure. So everybody will recall that about 2 months ago, the Biden administration through OSHA, the Occupational Safety and Health Administration, issued its emergency temporary standard, which was going to require employers to put in place certain policies relating to tracking employees' vaccination status, requiring whether the employer was going to require its employees to be vaccinated or not, and then if they were going to offer a testing mechanism for those employees who weren't vaccinated. And that needed to be put in place by December 4th, I believe, and then by January 3rd, 4th, or 5th, somewhere in there, the testing mechanism was supposed to go into place. You'll recall that on the program, we covered this in pretty good detail, what the OSHA ETS required. But while we were discussing all of that, the Fifth Circuit Court of Appeals stayed the implementation of the OSHA ETS. Now, there were many challenges filed in many different courts around the country, and under the federal courts mechanisms, all of the appeals of those decisions got consolidated into the Sixth Circuit Court of Appeals. And interestingly, from a procedural standpoint, we talked pretty extensively about the fact that the Sixth Circuit Court of Appeals had a very high Republican president high number of Republican president appointed judges. And it seemed that if the full Sixth Circuit was going to hear the appeal, that the Fifth Circuit's order would still stay in place, which stayed or basically, for lack of a better term, barred the implementation of the OSHA ETS. However, we also discussed on the program, Phil, that it's possible that a 3-judge panel, a normal panel of judges, would get to hear the appeal from the Fifth Circuit. Well, it turns out that a 3-judge panel did get to hear the appeal. Late Friday afternoon, the court issued its decision. Friday afternoon, Friday evening, the court issued its decision, the 3-judge panel. There were 3 judges, like I said, they all wrote separately. One judge wrote what they call the majority opinion, one judge wrote a very short concurring opinion, and then one judge wrote a dissent. Interestingly, it was a panel of all female judges from the Sixth Circuit. One of the judges, the one who wrote the primary opinion, was an Obama appointee. Another judge who wrote the concurring opinion, she was an appointee first to the district court under Reagan and then to the appellate courts under Bush. And then the third judge who wrote the dissent, I'll give you one guess, Phil, as to who appointed that third judge who wrote the dissent and would have upheld the Fifth Circuit's ban of the OSHA ETS.
Oh, now you're gonna. Oh, it must be Biden.
No, it's President Trump.
Trump. Okay,
President Trump. This is the judge that dissented and said that this should stay banned.
Yep. Go ahead. Yeah. Yes.
All right. So that's the panel.
Hey, don't put me on the spot like that in front of everybody, Burt. Come on, that makes me really uncomfortable. All right.
Sure, I'm sure. I know you well enough to know how uncomfortable you get, Phil.
Right.
So the basic the bottom line here is that the majority, the two judges that ruled in favor of dissolving the temporary restraining order, did say that OSHA had gone to great lengths to explain that this emergency standard was necessary to protect workers from a quote unquote grave danger presented by quote exposure to substances or agents determined to be toxic or physically harmful or from new hazards. And the majority concluded that regulating an agent that causes bodily harm, including viruses, is squarely within OSHA's authority. The majority talked about a long-standing precedent that addresses the plain language of the Act, the OSHA Act, interpretations of the statute, and examples of direct congressional authorization following the enactment of the OSHA Act, and that all showed, according to the majority, that OSHA's authority includes protecting against infectious diseases that present a significant risk in the workplace. The majority then went on to discuss about how in the legislation that Congress made available funding for protecting workers in the workplace. And so the court did find that the legislation that's been put in place to combat COVID did make this reasonable that OSHA would act and use its authority here. The one judge who filed a short concurring opinion simply stated that the judiciary has a limited role in deciding disputes about pandemic policy, and she even noted that reasonable minds may disagree on OSHA's approach, but she said the court should not submit its judgment for that of OSHA, which had been tasked by Congress with the policy-making responsibilities.
Oh, that's interesting. Yeah.
Yep. And then just real quickly, the dissent took issue with OSHA's decision to make the testing/masking option less palatable to employers and employees than vaccination, and found that OSHA could not show that the ETS was necessary or that COVID-19 posed a quote-unquote grave danger. And she said that OSHA had exceeded its authority because Congress had clearly marked the perimeter of OSHA's authority, which is the workplace walls. And she said that given that COVID-19 exists everywhere, an infected person may be at home, school, or the grocery store, the judge said, how can OSHA regulate an employee's exposure to it? And so very interesting how it got that, how the three judges all viewed this. OSHA, like you said, on December 17th, I think very late in the day, which you saw the next morning, posted a statement to its website saying how gratified it was about the Sixth Circuit's behavior. So here's the important part for most of the listeners on the call or on the program. To account for any uncertainty created by the stay, OSHA is going to exercise enforcement discretion with respect to the compliance dates. So those dates we talked about before, December 4th and I think it was maybe December 5th and January 4th. So to provide employers with sufficient time to come into compliance, OSHA will not issue citations for non-compliance with any requirements of the ETS before January 10, and will not issue citations for non-compliance with the standards testing requirements before February 9, so long as an employer is exercising reasonable good faith efforts to come into compliance with the standard, with the ETS. So we'll dive into that a little bit more in a minute here, Phil, but
this won't be an issue for our listeners, Burt, because we've been saying all along, we need to continue to prepare as if this is going to pass and be something we have to deal with. So I'm sure all of our listeners, they're kicked back right now, probably not even listening, just to the fact that they're ready, Burt. We've helped them all along the way.
Well, just in case there's one or two who aren't ready, I'll come back to it in a minute on what exactly the employers need to be doing. But let me close out the procedural piece of this first. So not surprisingly, almost immediately after the decision was issued, multiple plaintiffs filed emergency applications for an immediate stay of the ETS with, of course, the United States Supreme Court. Interestingly, those applications are going to be reviewed by Justice Brett Kavanaugh. He is the one who's assigned to hear petitions from the Sixth Circuit Court of Appeals.
Ask me who appointed him, please.
Go ahead. Who appointed him?
President Donald Trump.
You're right. You're one for one.
I just had to redeem myself here for a moment, Burt.
Justice Kavanaugh has several options. He can grant the petitioner's applications and stay the ETS pending review of the entire court, or given OSHA's decision to delay compliance dates, he could refer the applications to the full court for a decision. Justice Kavanaugh could also take no actions on the applications pending review of the full court. So all I can say on that point is that we would hope that the Supreme Court will be mindful of the resources necessary for employers to implement the ETS, and will try to avoid a scenario in which employers would take steps to implement the ETS only to have it invalidated later. So it's always difficult to predict how quickly the Supreme Court ruling might come, but hopefully the Supreme Court will take action in advance of January 10 to give employers some certainty. And I just bring up the January 10. We're only 21 days away from that. So
21 days with the holidays in between. Yep. Exactly what all of our wonderful employers want to be dealing with. But again, I'm sure we're along the way. So, Burt, let's just cap what you just said, right?
Sure.
So, in short, the Sixth Circuit Court of Appeals has said, hey, we believe OSHA is within their limits. 2 out of 3 have said yes. Therefore, the game is back on. And we have until January 10th to have our record keeping and planning and things in place. And then until February 9th to start our testing protocols, should we choose that to be an option within the new temporary standard.
So I think you're pretty much on target, Phil, and let me make it very clear to those who are listening on what needs to take place. The OSHA Emergency Temporary Standard requires covered employers with 100 or more employees. So that's the first piece of it there. You have to, in order to be covered, you have to have 100 or more employees. And you have to employers have to determine and folks may want to write this down, or we can send it out as a reminder afterwards. So employers with 100 or more employees have to determine, number one, the vaccination status of each employee. That's number one. Second, they need to keep records related to the vaccination status. Third, they need to provide specific information about vaccines. Fourth, they need to develop and implement written policies describing the requirements with regard to vaccinations and testing. They have to do those things by January 10. So
right.
If you don't mind,
how are we going to help them out, Burt? I believe this is just a great time Phil, to talk about your offering.
It is. Let me just finish real quickly. The ETS also allows covered employers to permit employees to undergo weekly testing rather than be vaccinated. And I want to stress there that the ETS allows covered employees to permit, allows them to permit, doesn't require them to permit. It allows them to permit employees to undergo weekly testing rather than be vaccinated. And if they're going to go that route, that has to be the weekly testing of vaccinated employees must begin on or before February 9, 2022.
So what you're saying there is that's an employer choice, that the standard allows the employer to make that choice to weekly test or not. You're not required to weekly test if the employer wants to say, we're just going to require everyone to be vaccinated and forget about it.
Correct. And it's interesting because I mentioned a little bit about the policy goals that were cited by at least the judge who wrote the majority opinion, and then the judge who wrote the dissent. Remember, the policy goals of the administration, the Biden administration, for lack of a better term, really are to make life as miserable as possible for those who do not want to get vaccinated. And so this testing mechanism and continued masking is part of that policy.
Gotcha. All right. So Burt, I'm just looking at the chat. I can see Chuck is asking a question about large employers. Would this apply to contractors working on a large company facility? And I think that answer is yes, it could apply to those contractors.
It's possible it could apply to those contractors. First, one of the entities, either the employer contractor or the entity on whose site they're working, if either one of them is a large employer, then likely there's going to be an obligation. But I would need to look at the legal specifics of the situation.
Yeah, and Randy is asking a great question here. Where can we find a list of state-specific guidelines related to the OSHA mandate? For example, he's referring to Utah and so on. And I know that Ogletree has a great package available for people that handle every state-specific guideline related to this, plus some. And can you just give us an overview of what is available? Because I suspect people are going to need a little more help here.
Sure, of course. And you can get this information if you want to reach out to me at Burton, BURTON, .Garland, GARLAND, at Ogletree.com. Phil, we could probably get this, what Nick has put on the screen for everybody, posted on your website as well.
We'll put it there. Yeah.
Yeah, but Ogletree, we've got a emergency ETS set of templates that we have made available to everyone, to clients. And so if you're interested in just these packages, you'd have to quickly sign up to become a client, and then you can take advantage of purchasing these packages. It's divided into 3 pieces. The first one is package A. That's the template vaccination policy and forms. And for $900, you could see on the screen that you get template vaccination policy with options to require either vaccination or vaccination with weekly testing, an executive summary of the vaccination policy and considerations, forms to establish a process for submission of the exemption requests, sample letters granting or rejecting accommodation requests, sample COVID-19 vaccination attestation forms, sample OSHA ETS information sheets for employees, and sample COVID-19 vaccination FAQs, and that's a $900 package. Not surprisingly, we've had to break this out for California. California has got its own package that is California specific, and that's an additional $500. Purchasers of one of our prior template packages get discounts. There's also a package C. There's an updated 50-state survey, and I think this was the one you were getting at, Phil. This 50-state survey, which is $2,000, but the amount of material that people get under the survey, you could not duplicate for even close to $2,000. There's a 50-state survey on state law accommodation standards, where those differ from federal. There's a 50-state survey on state law limitations on mandatory vaccine policies. So that would mean, does the OSHA ETS run afoul of a state law? There's also a 50-state survey on state laws potentially requiring employers to pay for the tests, or even when the ETS does not, plus a detailed analysis of the compensability of testing time. So again, there's a wealth of material available in these templates. If you had tried to go out and recreate this yourself, or retain me or any other attorney to try to recreate these packages, it could not be done for these prices. There's a wealth of information in there that will really aid all of your members and all of our clients in heading down this road and doing what they need to do to become compliant with the ETS.
And you get the updates as they change. That's important to recognize as well. All right, Burt, let's, I'm getting several questions here. Good morning, Elizabeth. I see her question as it's relating to how we calculate the number of employees. I don't believe that has changed from the original intent.
That's correct, Phil. So let me take a second to talk about how that is calculated. We'll go back, we're getting close to 2 years now, to the Families First Coronavirus Response Act, and I became one of my firm's experts on that issue, dealing with clients literally across the country on this issue, on counting whether employers were required to comply with the FFCRA. And you'll recall that under that standard, that basically they looked at a 4-factor analysis that determine whether employers could be considered really a joint employer or an integrated employer for purposes of the FFCRA. OSHA in its ETS was much more narrowly focused, and what they are really looking at is whether safety is done at a corporate level, an overall corporate level, or more at the entity level. And so if you are a corporation with various subsidiaries, various locations throughout the country, if safety is centralized, meaning that it's run from corporate down to all of the facilities or all of the holding companies, then in all likelihood, you're going to have to count all of your entities together. If safety is done at the facility location, you've got a safety officer at that facility. Very importantly, OSHA in the past, when they've come in, they've never sought to sort of go up the food chain to try to get to the larger corporate entity. If they've always stopped at the lower level corporate holding, I think that gives you good evidence that you look at it at that entity level, and it's not going to be judged or they're not going to try to say that no, safety's done from the corporate level and we're going to work our way down.
I think that maybe a point to just discuss for a moment there, Burt, is you have a local safety person and you have a corporate safety person, and the corporate safety person may provide direction, oversight, might even come in from time to time and do, you know, some inspections and
training
types of things, training. Then you would have corporate oversight.
Well, yeah, and it depends on the amount of that corporate oversight. I think if they're coming in and corporate sort of setting general policy and saying, here's a suggested safety policy that you might want to implement, and the local, the lower level holding decides, well, we're not going to follow that. We're going to do our own. Then I think you're in a situation where it's more likely that the analysis would stop at the lower level holding. But if corporate comes in and issues a safety policy and says you must follow this, and yes, we have a safety director at the holding, at the subsidiary, but that safety director really is not empowered to do anything without the approval of corporate, well, then I think you have your answer that it's probably done at the corporate level, and we're going to have to aggregate the subsidiaries with the parent for purposes of counting the 100.
Okay, now let's just take that one step further, and we have employees just spread out all across the country. There's not 100 employees at any one location. We don't have a corporate safety officer. We just have people everywhere. But let's say we have 115. I think this gets to a couple of the questions in our chat. They don't all work together.
But in aggregate, we have 100 or more employees.
Correct.
And so I think that's the answer to that. It doesn't matter
some
that
of the questions that we see in the chat where, you know, the employees who are working from home and have no intention to come back into the office, they would count and would also need to comply with the standard from either a vaccine or testing standpoint.
Which is really quite amazing, but yes, that's the way it's been written. And we'll have to see how that exactly flushes itself out if they're literally not going to be coming into the office or having contact. But theoretically, yes, this OSHA ETS would apply.
Yeah, more to come on that, I'm sure. That will be one of the big questions for sure. Let's see. I'm just looking at all the questions. There's lots of questions here. We're going to try and get to all of those. Yeah, I think we answered your question, Connie, with 115 employees, but 100 are completely remote. I think you're going to have to aggregate them together for the initial compliance of this until we learn more. It won't necessarily just affect only the 15 that work together. Temporary employees would count with this the same way, Burt. If I remember correctly, you would count the temp employees that are
I believe that's correct.
Yep. I believe I remember something on that.
Here's a good one, Phil. Has there been a change as to who has to pay for the testing?
Yep.
This is from
Mary Lou
Keenye, who has asked that question. And no, there has not been a change as to who has to pay for the testing. Remember, under the OSHA ETS, it specifically allows the employer to shift the cost of that COVID testing to the employee. Now, that said, remember what I said when I was talking about Ogletree's templates, there are going to be some states out there that are going to prohibit the shifting of those costs to the employees. But under the OSHA ETS, it does allow it. The other thing I will say is that if you are accommodating somebody from a religious standpoint or a disability standpoint, it might not be a very good idea to try to shift the cost of that testing to those employees, because then you are treating those employees differently than somebody who is able to get vaccinated and that therefore won't incur the charge for the testing. So just be cautious of that.
Yeah, for that one for sure. There's a question about the boosters, which I think is appropriate. And at the time when the standard was being put together, a booster was not the focus that it is today. And the question is that I don't believe the OSHA standard necessarily covers the requirements of tracking the boosters, but obviously it's going to at some point apply. I think it would probably be a good idea. I don't think we'd be overstepping our bounds to capture that information if it was available.
Yeah, I'd probably take a slightly different read, Phil, and say that what OSHA is requiring is they're requiring employers to document the vaccination status of its employees.
Yeah. And this is why you're the lawyer. Absolutely. That's a great way of seeing it.
And the definition of what it means to be fully vaccinated has changed from time to time. Initially, it was one shot and then followed by a second shot for the 2 vaccines, 1 shot for the J&J. And now to be considered fully vaccinated, you have to be boosted. And so employers are required to track the vaccination status of the employees. And so I would say that it already requires tracking of the boosters. And I use that plural because I think boosters, everything I'm reading is that, they're talking about 4th booster shots now, or 4th shots.
Yeah, it looks like Mary Lou has already purchased your program, and she's talking about changes. Mary Lou, I know that Ogletree has done a great job. As changes occur, they keep that up to date. So I think it's always a good idea to make sure you have the most recent versions from Ogletree when you're starting to implement a policy, Mary Lou.
Yeah, Mary Lou, those will be, if there are any changes, those will be pushed out to you. I would imagine that you'll receive at least something just reminding you of the new dates. But really, the court's decision did not change anything from a substantive standpoint related to the ETS. It just kicked the dates down the road to account for the time that the ETS was stayed by the Fifth Circuit.
And Burt, are you familiar with any mask mandates that go along with the standard for vaccinated or unvaccinated employees?
So yeah, as part of the OSHA ETS standard, if you're going to allow the testing piece of it, and it's been a while since I've read it, but I believe that as part of that the employees still need to try to physically distance and they need to mask.
Yeah.
I'll double check that, but I think that it still does require masking if you're unvaccinated.
All right. And then there's just a couple questions here as just relates into calculation of the employees, for organizations that fluctuate. And I believe there is some rule or standard as it relates to how we get to 100 for employers that are fluctuating.
Yeah, the OSHA ETS doesn't say a whole heck of a lot about that, but I would say out of an abundance of caution, if you cross 100 and you look like you're going to be staying at 100, even if you dip down for a day or a week or 2 weeks, I would still try to maintain my compliance. If it looks like you're going below 100 and are going to stay below 100, then I think you might be able to back away from it. Again, I would need to check the ETS on that specific issue. Remember, the other thing is, I don't remember the exact end date to the ETS, but it was only something that was supposed to be in effect, I think, through April or May or June at the absolute latest. This is not in the grand scheme of things, a long-term ETS. Remember, it is just that, an emergency temporary standard, and those can only be put in place for so long.
Yeah. All right. One of my good friends, Philip here, he's basically saying he was hoping to avoid the exemption process altogether. But I suspect we'll have some valuable employees that refuse to submit weekly testing in February. Any advice for how we're going to handle or would want to handle employees who are going to not be vaccinated and or submit weekly testing? And at that point, I suspect after we go through the right process, then it really comes down to some sort of temporary layoff or permanent separation.
Yeah, as much as from a employment standpoint, I hate to see that, especially given the economy right now and the lack of people in the workforce. I think this is just going to compound things. But I think that's right, Phil. I think that if you have an employee who is unable to get vaccinated or refuses to get vaccinated, but then whether they're disabled or there's a religious component to it, if they refuse to go through the alternative mechanism, if that's offered to them, and that's the testing, if they refuse to submit to that, then I think you're right. I think the employer is going to be in a position where it can terminate the employees or put them on a long-term leave.
Yeah. All right, Bart. Let's just recap everything before we go here. I'll give it a shot. You can do the correcting as we go through this. So the new standard as it sits today, without any additional rulings by the Supreme Court, which I believe earlier in the pre-show, you and I were saying the appeal has already been filed with the Supreme Court. So we expect the Supreme Court's going to hear this. We just don't know when.
We expect that, well, like I said, Judge Kavanaugh's got 3 decisions or 3 options here. He can stay it pending hearing it. He can allow it to move forward pending the court hearing it, or he can take no action and say that the court's not going to hear it.
Gotcha.
So I do think we'll hear something quickly on which of those 3 options he's going to exercise.
You don't think he's calling Trump asking for advice, do you?
Oh God, I hope not. not that I hope not from a political standpoint. I would just love to see the Supreme Court not get wrapped up in politics. So that's all I mean by that.
I like to believe that we keep those put to the side.
Yes.
All right. So if you have 100 or more employees who are all governed at one particular location or across the country, then you would need to be vaccinated and or provide testing in order to stay employed and an active employee. As employers, we have to do a few things. We have to have vaccination status of employees. We have to do the record keeping. We have to provide very specific information that's all available in your documents through Ogletree, which you'll be able to link to off of our website and or email Burt, and he will take care of you. You have to have the policy and requirements of your site and undergo weekly testing is an option if you choose the weekly testing, but it's not mandatory.
That's right. And this is basically the big deadlines to keep in mind. Sitting here today, right now, who knows what the week will bring to us, but sitting here today, January 10 and February 9, those are the big days everybody needs to keep in mind to comply with the ETS.
All right, Burt. Producer Nick, thanks for joining us this morning. I appreciate you joining us at the very last minute on this. Burt, great job doing your research once again. Look up the Ogletree documents. I would get those and let's get to work if we're not already prepared. And we will be back on the air, I'm sure, with lots of questions in January with more information on the Emergency Temporary Standard. Everyone have a happy holidays and happy New Year's. We'll see you then. Bye-bye.
Tell your story, promote your products, communicate with your employees and customers vividly, dynamically, and powerfully. Whether it's a company video, recruitment video, online training, or live meeting, Feature Group can help you, from scripting to highly polished finished production. Whether it's live or on demand, we have the skills and equipment to wow your audience and drive your message home. Feature Group USA, the one-stop shop for all your broadcasting needs.